You're welcome back. This is The Law. It is your legal light. It is your health law. And here on this show, we give you platinum legal education. This afternoon, once again, I'm joined by two of my good friends so that we can help you appreciate the law in a manner that helps you to avoid being arrested, being taken to court, and potentially being put in jail and coming out with the tag ex-convicts. It might deny you the opportunity of getting your dream job when you do the things you do on social media, avoiding the Abronye 207 and 208. Here in the studio is Apanga Lamte, who is managing partner, Prestige Partners. He's not a stranger to this platform. Also joining us via Zoom is Daniel Korang, who is partner at Doom Legal Consult. He's also an author of several legal texts. He particularly is no stranger to this platform. Gentlemen, good afternoon, and thank you very much for joining me on The Law.
Good afternoon, Samson.
Great, Daniel. Good to hear you. Right. Okay, so let me begin by giving our viewers a setting by way of introduction, getting you to know how this law has caught up with a number of people in recent times. How these two laws, Section 207 and 208, have caught up with a number of people in the country in recent times. I'm taking you through a list of people who have had to face this law. So join me on your screen, and you will remember a young man by name Mohammed Ibrahim. He gave himself the name Kaneu, that is his alias, Kaneu. We understand that he is an NDC constituency organizer at Soto. He spoke and he spread false news of the IGP recruiting fake personnel to kill Ghanaians during the 2024 general elections. You know what happened to him? He's got 4 years in jail because he said things on social media that were deemed to be false. He was charged and he's been locked up as we speak. In fact, before Ibrahim was the blogger Jeffrey Nyame. He was arrested and charged in 2022 for his publication that was said to have caused panic withdrawals of dollars. He was sentenced to 30 days in jail in 2024. Despite pleas for pardon or just for a fine, he had spread the information that the Bank of Ghana had issued some notice that those who were holding dollar accounts, they would only be allowed to withdraw money in CD equivalent and not in the dollars that they took to the bank. He was lucky. He got 30 days in jail. As you are aware, the following people have been arrested and charged under these, provisions of the law. Prince Ofori, known as Fante Comedy. Yayira Abeu, known as Akosia Jollof. Emmanuel Kwachi also have faced these charges in our court. We have Daniel Adomako, known as Sir Obama Pokwase. He also is charged, was arrested, and has been charged. He has to prove his matter in court. If they were true, Kwame Bafo, that is Abronye, the NPP's chairman in the Bono region, he also has been charged under this law very recently. He was seeking bail and many attempts didn't work. So he spent quite some time in custody. There is Kwame Asari, Wuntumi FM journalist earlier. He also had difficulties getting bail after he was also charged. One count of offensive conduct in connection with the publication of alleged false news with the intent to cause fear and alarm. There was Mensa Thompson. A couple of years ago, he was also charged. He had suggested that Akufo-Addo, was using the state's plane to ferry his family around somewhere in London or somewhere they were doing shopping. He made those claims on social media, right, and put them out in the public. He got arrested for them, and he was being pursued in the court. There's Bobi Ansah, Accra FM journalist, has said some things about the First Lady, about some acquisition of land. And then we have Parkwesi Samson, Connect FM journalist, also for publication of fake, news about kidnapping story. That's quite a bit I've been able to take you through just as a way of a reminder. Let me begin with sections 207 and 208.
Yes.
Are they good laws?
Good afternoon to you, Samson. Good afternoon.
Good afternoon.
A law is a law, and it's not in my place to say it's a bad law, a good law. There is a clear intention of what the law is supposed to do. We all appreciate that in the public space, we're supposed to have a law or some mechanism to ensure public safety, to ensure that the public is not misled, to ensure that the public are not, for lack of a better word, aroused or put in a place where they will react to certain false information, or you may incite one group against the other. That will generate unnecessary public
Tension.
On arrest or safety and create problems for everybody. So for all that, you may think that it's a good law. On the other hand, if you look at it from the human rights perspective, you may think that it is a limit to free speech. It inhibits the ability for people to express themselves, say the way they want to say it. But you must appreciate that even with the right to free speech, there are limits to it. That is why when you abuse someone's right, the person can take civil action against you, right, in defamation or a libel suit. And so I wouldn't describe it as a bad law, but perhaps it is coming out a bit more now. It's being used now and activated more and more, and so we are seeing it as a means to punish free speech. But I think it's a way to ensure public safety.
Thank you. So these laws should remain in our statute books?
I think so.
Thank you. We'll come for you to justify your points. Yes, Daniel, 207, 208, good or bad laws?
Samson, thank you very much, and good afternoon to your viewers. I think sections 207 and 208 of the Criminal Offences Act is a very good law and should not be removed or tampered with. Having regard to the proliferation of social media and its power to influence, incite, and inform masses across the country and across the globe. You see, in these times where social media is, making it possible and easy for people to put just anything in there, which is easily accessible to the public, it is important that we tighten the law on the use of social media to avoid abuses. We know that the traditional functions of the media are to educate, to entertain, and to inform. But when we go to our social media platforms today, we see that these important functions are not what we use our social media platforms for. So people go to social media not to inform, not to educate, not to entertain, but to lambast, to denigrate, to insult and abuse others. So I think that in order to sanitize the system and to ensure that we commit ourselves to the principles of, respecting the rights of others and peaceful coexistence, it is important that we keep the law intact with its coercive force, so that we would get people to, be responsible communicators and users of social media particularly.
Okay.
We cannot leave people to, do whatever they like with social media.
Right. So the two of you are going to give me a difficult job this afternoon. Since the two of you agree, you say these are very good provisions of the law we need, particularly in these times of a lot of misconduct on social media by way of speech. You didn't say very good. You said, yeah, they should remain.
Yeah, I think so.
Now, let's get to meet these laws. And in this year alone, this will be about the third time in the year that I'm seeking to bring these laws up to educate all of us. I believe that we must educate each other as frequently as we can, for as long as they remain on our statute books, to help us so that we avoid getting into trouble with these laws. I mentioned to you the blogger Jeffrey Nyame. He was arrested in 2022. Eventually he was convicted in 2024. Can you imagine? He would have spent almost how many years going to court, up and down, coming. It's not pleasant. And depending on the kind of work you have, if you don't have your own business, you may even lose your job because of some very reckless statement you make on social media. Well, let me not get ahead of myself. What are these laws? What do they say? Let's read together section 207. These are the very provisions that have been used against Abronye standing trial now. 207 is titled Offensive Conduct Conducive to Breaches of the Peace. Any person who in any public place or at any public meeting uses threatening, abusive, or insulting words or behavior with intent to provoke a breach of the peace, or whereby a breach of the peace is likely to be occasioned, shall be guilty of a misdemeanor. That means you can go to jail for 3 years maximum. Then section 208 is titled Publication of False News. And it is with intent to cause fear and alarm. It says any person who publishes or reproduces, either you are the author or you are just sharing. So reproduce, let's say you are sharing any statement, rumor, or report which is likely to cause fear and alarm to the public or to disturb the public peace, knowing or having reason to believe that the statement, rumor, or report is false, is guilty of a misdemeanor. It is no defense to a charge under subsection 1 that the person charged did not know or did not have reason to believe that the statement, rumor, or report was false, unless he proves that prior to publication, he took reasonable measures to verify the accuracy of the statement, rumor, or report. Okay, now help us appreciate why you say this is good law and it should remain in our statute books.
Samson, I'm sure by the time we finish looking into what goes into the law, we'll begin to appreciate why it's a good law. Now, you know that as human beings, we all have the tendency sometimes to go overboard, to behave in a manner that may not be acceptable, in a manner that could also lead other people into acting in some other manner that is also not acceptable. And so in order to bring all this behavior into check and to ensure that we don't live in a society where we have people fighting and creating problems and chaotic situations here and there, This law is meant to protect that. Now, let's deal with 207. 207 says that any person at a public meeting or a public gathering uses abusive words, threats, insults, that person is guilty of misdemeanor.
Insulting words or behavior.
Insulting words or behavior, to the extent that even sign language, because if you don't use the words, but you behave in a manner that is abusive or could.
That it is with intent to provoke a breach of the peace.
Yes. And you know, with the issues of intent will only be inferred from your conduct. You may not intend a particular outcome, but your actions have resulted in a particular outcome. So intentions now will be inferred, and that's what we refer to as mens rea in legal jurisprudence. And so something, it is to ensure that I will not rise up in any public place and insult someone or threaten anyone or use abusive language or even conduct myself in a particular behavior that is likely to disturb the public peace. We all appreciate that the tranquility we enjoy and the coexistence we have is born out of the fact that we all behave in a good particular manner. But the moment we are tempted to go down the road of insults, and mind you, the law limits itself to public place, public space. So this may not include two siblings having their fight at home, two neighbors having their fight at home, or husband and wife having their matrimonial issues at home. But where you are having this disturbance or insult or use of those words in the public space. Now, public space, the definition of public space has expanded to include social media, the regular media, and even to the extent of Facebook, WhatsApp group platforms. So that when you're on a group platform and you use insulting language, you use abusive language, or you behave in a manner that will disturb the public peace, you are guilty or you can be charged with this offense. And the idea is that it is to ensure that we don't go overboard. Let's stay within limited and acceptable scope.
Daddy, I'm coming to you, and for the purposes of this continuing education for our viewers, in 1984, a matter came up. There was someone who was beating the gong in a village. And he was telling people that no one should pay levies. They were being asked to pay levies. And he was beating the gong to the effect that no one should pay levies. It was found that it is not offensive, nor is it abusive conduct within the meaning of Section 207. This was Kungwa. There was another person by name Gaba, who also, as we understand, was held not to have committed the offense because what he was doing was happening in a private house. It was a quarrel in the house. So the court said because it was happening in the house. This was 1984. So I've given you two cases from 1984. There was also the matter of Kwanzaa in 1980, that is even earlier. He also was said to have caused the beating of the gong, announcing the destoolement of the head of family in the frontage of a house. An attempt by members of the family to snatch the gong resulted in a breach of the peace. And it was held that in considering the meaning of Section 207, the test of a reasonable man is inapplicable to the persons likely to be provoked. The perpetrator has to take his audience as he found it. The test of a reasonable man is applicable in deciding whether the relevant act was done, quote, with intent to provoke a breach of the peace. I'll go to two more. The case of Brutus. This is in England in 1972. He went to a tennis, championship tournament. He blew a whistle and threw leaflets about. That particular act produced resentment in many people. He was convicted of insulting behavior, and it was held that insulting must be given its natural meaning and not merely conduct which affronts other people. And finally, Gla and another, that's in Ghana in 1992. This is someone who had married a woman with whom he had 2 children. He also married the woman's sister, as well as their mother, and had 2 children each with them. They all cohabited in the same house about 17 years. The community, finding the conduct of Gla offensive, had him prosecuted on a charge of engaging in offensive conduct in a public place that was conducive to a breach of the peace. He was convicted and he appealed. On the appeal, it was held that he had not done anything in a public place that could cause anyone the offense, and therefore it was the people who found the fact of his cohabiting with his wife, sister-in-law and mother offensive, who had to be restrained from conducting themselves in such a manner as to cause the breach of the peace. I intentionally went through this history. Why do you say this is very good law?
Thank you very much, Samson. Let me mention that the law we are talking about, sections 207 and 208 of Act 29, is part of our criminal law. And one distinctive feature of our criminal law is that it has its own measure and standards of proof. And so when one is alleged to have committed a crime, it is not about what people are saying on social media or what somebody thinks. It is about the criminal law's own measure and standards of proof. Now, when you take Section 207, that is offensive conduct conducive to breaches of the peace, it is important to understand that every crime, every criminal offense has its own elements. When we say elements, we are talking about what the police or the prosecutor must prove before a person may be convicted of that particular offense. So you don't go to court and just say that this person has done this and that's all. No. You have to prove certain basic ingredients of the offense. And the standard of proof is one beyond reasonable doubt, very high. Now, let me break Section 207 down for our present purpose. When anybody is charged with the offense of offensive conduct conducive to the breach of the peace, the following must be proved, the following elements. The first is that what we are talking about as being offensive conduct took place in a public place. It took place in or at a public place or in a public meeting. What this means is that when something happens in a purely private setting or private place, the law does not concern itself with that. And what a public place is has been explained in the law to include a public highway or a public building where the public have access, free access to, or where the public can pay and access the place, like a mosque or a church or a place of public performance are all classified as public places. So when we have a place that is strictly private, nothing can be said to have been done there to breach the peace. So the first element is that the conduct we are talking about must have happened in a public place.
Right.
The second is that...
But the first element, Apanga says that now social media?
Social media today, by a purposive, liberal understanding and interpretation of the law, we would say that social media is a public place.
Okay.
The reason is that now so many things have changed because of the advancements in technology. And so what didn't used to exist, today exists. We have to understand that the law we are talking about was enacted somewhere in 1960.
When we would have met at the village square.
Yes, under some tree.
Yes.
Yes.
Yeah, I said the palm wine joints. That's a good example.
Yes. So, by virtue of the technological advancements that we have experienced over the past decades, it is important for us to interpret our existing laws liberally and with the spirit that we want the law to advance and have meaning and relevance, to our present setting. And so social media is squarely caught by the definition of public place or public space.
Let's go to the second element.
The second element is that the action we are talking about, the attitude or conduct we are talking about, must amount to a threat. You see, somebody issues a threat or threatening words, must amount to abuse or abusive language, abusive words, or insulting words or insulting behavior. Now, it is important here to note that when we talk about threats, it is threatening the peace in society.
Okay.
I've always said in my criminal law class that the criminal law is not only limited to the protection of life and property. And when you look at chapter 3 of Acts 29, that whole chapter 3 concerns itself with offenses against the peace. That is the public peace. And from sections 196 up to sections 209, all deal with offenses against the public peace. What this means is that the criminal law recognizes the peace in society as very essential commodity that must be jealously protected and safeguarded. So we don't only concern ourselves with protecting lives and property. We want to maintain and preserve the peace, the tranquility, and the serenity that we enjoy in society. Because no society can flourish or progress in an atmosphere of chaos or rout or violence or where there is no peace. So if somebody issues a threatening word or abusive conduct, that abusive word or insulting words could relate to somebody else. It could relate to the government. It could relate to a state institution. It could relate to just anybody at all. So that's the second element, a threat or abusive words or insulting behavior. And the second most important element is that the person issuing these threats and abusive words must have a clear intention. That intention is to provoke a breach of the peace. So we have to understand that these two offenses we are talking about are intentional crimes. When we say intentional crimes, it means that they must be deliberately engaged in. They must be done with clear intention of provoking the peace or inciting people to engage in the breach of the peace. The intention must be there. And the last element, that is the fourth one, is that putting all these things together, the breach of the peace is likely to happen or has actually happened. So when somebody has uttered some threatening words or abusive words or insulting words, we must convince ourselves that these words or conduct have actually breached the peace or they are likely to result to the breach of the peace.
That brings in my question. Apanga, shouldn't it be that it has actually caused the breach of the peace before a person can be held to have committed an offense?
Unfortunately, that is not the case.
Why not?
The law says likely. Likely. So if there's a likelihood that that conduct, that behavior, those words spoken, which are abusive, threatening, or insulting, are likely. A clear example is one of, I think, a pastor who predicted that the chief imam is going to die, and in the next few days, some young men from the Muslim community attack his church. They only destroy the signage of the church. Look at that situation. If those boys were not calmed down and they had continued, you can imagine the effect of that.
So in that case, there was actually the results.
Yes, there was an action.
Had occurred.
Reaction.
But when the result has not occurred, it says likely to result in the breach of the peace.
This is one of the laws I would say is even unique. It is preventive in
It's
nature.
vague and too broad or unique.
I think it is unique and preventive in nature to the extent that it anticipates the likelihood of breaching the public peace.
Who will then determine that what you have said is likely to produce the outcome for which reason you must, face the law?
You and I know that it's only the police and perhaps the prosecutors who are in charge of criminal prosecutions in Ghana.
That's too much discretion.
So for the police to determine that this is likely, and that is the use of discretion here. There is for the police to use their discretion to determine that the words you have spoken, the conduct or your behavior is likely to disturb the public peace.
I'm in a group where we are used to certain harsh words and certain conduct that shows that we are going to hate each other, but we are not going to do it anyway. Then you hear me or you see me attempting to do that and you arrest me. Meanwhile, in fact, I wouldn't have done it.
Samson, every situation will be looked at differently. In some situations, there may be complainants who come to the police station to complain that Mr. A, Mr. B use certain words on a group of us.
Right.
And these words can cause some public disturbance. I'll give you a clear example. Back home in Bolga, it is very open and known that a lot of the people would tease Nabdams and say, why are you behaving like a Nabdam? Mm-hmm. We joke over it, we laugh over it. But if it is said in a manner, in a public place, like I'm on TV now, or you are not one of us, and you say that, or we between the artists and Franfres, we have this very good relationship where we
slave and
exactly. If we say that, and that's where we infer the intent. The intent here is not to disturb the public peace. It is a friendly relationship between the two parties. That is all right. But where it is said with the intent to cause some public disturbance or likely to cause public disturbance, there's a need for you to answer to it.
Daniel, I'll ask you the same question before we move quickly to 208. Why should it be a question of likelihood rather than the actual thing happening before you deal with me?
All right. We have to understand that the criminal law does not only deal with actual happenings. It also deals with things that are harmful, which are likely to happen. So just as my brother mentioned, the criminal law takes preventive measures to ensure that whatever is hurtful, whatever is harmful, whatever is injurious or dangerous is prevented from happening. When it does happen, the law deals with that. But when you do anything that is likely to cause that harmful thing to happen, your actions should not escape punishment. But let me mention that this law particularly is very fluid. It is fluid in the sense that it doesn't have shape and form. It is formless, it is amorphous, and very likely to be abused and weaponized by majority groups against minority groups, particularly politicians. But let me differ a little from what my brother said, that whether something is likely to cause the breach or not is not a function of prosecutorial discretion. It is a function of judicial decision-making.
But it is the prosecutor that begins the whole thing.
Exactly.
Now, my brother, the prosecutor can think anything. You can go to the court, and the judge will shoot you down and say that you thought that it amounts to breach of the peace, but sitting here as a judge, looking at the law and the facts, I do not see that this conduct is likely.
In the same way that the prosecutor may have their idiosyncrasies, the judge may also have their idiosyncrasies. The thing that is deemed abusive by a prosecutor, another judge will feel it is not abusive. The thing that a judge feels is abusive, I sitting somewhere where the thing actually happened may feel I don't see any insulting nature of it, I don't see any threatening nature of it, I don't see any abusive nature of it.
That is why the law has never given the prosecutors the power to make conclusive decisions. They have the discretion to say that your conduct amounts to the breach of the peace. Whether that is influenced by malice, or by passion, or by hatred, or by resentment, nobody cares. But once you present the person or arraign him before the court, you present your evidence, the judge will now take a decision that is a judicial decision having regard to the evidence and the law. And so when the judge also takes a decision and you disagree or you are dissatisfied, you can appeal. So we don't have to make it look as if a judge has the right in law to kind of...
Okay, let's quickly go to the second one, 208.
Yes.
What's your basis of saying is good law?
Well, Samson, you appreciate also that falsehood and the sharing of false information or false reports
Or rumor,
particularly the part that is rumor, knowing that it's rumor. And it goes on to even say that where you have reasonable cause to believe that it is false, and you still go ahead to share. You may not even be the author. You may not even be the one who wrote it, but because you have found the information to be exciting, without verifying, you go out there. I think that I would want to even approach the authors of this law, that you could think ahead. In 1960, close to about 70 years or more, they could think ahead and come out with laws that even today are very applicable. Something, imagine a situation where someone comes out with complete falsehood, like we experienced some years ago when someone said there's going to be an earthquake and there was going to be an earthquake and almost everybody moved out of his house, panicking, fear, and all over the place. Fortunately, today, with advancement of technology, information reaches people far before the state agencies that are responsible can react. And so if we don't have some of these laws that can curb the situation where we can prevent people from spreading falsehood, which may likely lead to public unrest or some disturbances, it is important. Mind you, it's about the sharing of false information. The law also makes room for you if you have taken steps to verify. So if you receive some false information and you think that there's some cause to doubt this information and you Googled it, you went into your search engine, you called 2 or 3 other friends and you verified, and about 2 or 3 people were all mistaken to believe that it is true and still spread it. That could be your defense. That, oh yes, I took 3 steps, I took this step, I took that step, and the step ensured.
So in the case of the Jeffrey Nyami, who was sentenced to 30 days in jail.
Yes.
Because he said the Bank of Ghana is saying that if you have dollar accounts and you go to the bank, they will only give you cedis.
Yes.
How could he have defended himself such that he would not have been jailed?
Well, I don't know who know exactly the fact of the matter, but I think that he could have verified from Bank of Ghana.
Okay.
Because this particular information...
So if he said he verified from JoyNews, that would not be good enough?
That's not good enough.
Okay.
That's not good enough, particularly when Bank of Ghana is even closer than JoyNews. Because Bank of Ghana has a website. Bank of Ghana has a complaint section. There's a desk you can call to verify the information. Besides, you're not the PRO for Bank of Ghana. Why take on yourself, busybody, spreading information from your... Bank of Ghana needs to put some announcement out. They pay for announcements. Why would you want to render free service for Bank of Ghana? He may perhaps had a good defense if he said, oh, I checked with Bank of Ghana and it was verified. If he can produce something to show that it was verified, so be it. Bank of Ghana may have changed an earlier decision. And perhaps that could be a good defense. But in his situation, I'm sure he didn't verify. And he spread the news out there already. And it was false news, turned out to be false. And of course, he paid the price by 30 days in prison.
Again, I'm sure Daniel will want to take us through what the elements of this particular crime is in 208. Yes, Daniel.
Thank you very much, Samson. Let me break down the section 208. But before that, let me mention that information is very crucial to the flourishing of any society. And so it is a very important concern of the criminal law to ensure that whatever information we put in there or we feed society with is very accurate and beneficial. And so we have criminalized publication of false information or false news that is done with intent to cause alarm to the public. Now, by way of breaking this section down, let me say that before somebody can be convicted under section 208, 4 things must be proved. 4 basic elements or ingredients must be proved. The first is that the prosecution must prove that there has been a publication. And publication includes spreading something, sharing something, or reproducing something, information. Sharing, reproducing, or circulating. In today's terms, you circulate on social media. That is publication. The second element is that circulation, publication, spreading must relate to a statement or a rumor or a report that the person has, circulated a statement, a rumor, a report, or a write-up. Then the third is that circulation or publication of the information was done with the intent to alarm the public, or that the person who did it has the knowledge that this thing will alarm the public, or that thing is likely to alarm the public. And the fourth point is that the person must have knowledge of the falsity or the untruth of the report or the statement or the rumor that he shared. When you go to the court, the police must prove that this person did not only publish a statement or a rumor that is likely to cause alarm, but the person knew or ought to have known. He ought to have had reason to believe that this statement I am publishing is not true or is false. So that here we are talking about the law effectively curtailing deliberately publishing information that you know or ought to have known that is false and is not helpful and beneficial. So it is not just a matter of putting anything there. Today, when somebody is on a platform, WhatsApp platform or any social media platform, information comes to the platform, the person doesn't read it, but forwards it. The person will just forward it to a friend or another group without even bothering to know what it is. Now, when you do this and the information is one that is false, it turns out to be false, you will be guilty of the offense.
Even though you are not the one who authored it.
You're not the one who authored it.
You only shared it. You only forwarded it.
You forwarded it.
But that's not fair.
My brother said, even though it was made in 1960, it had a very clear, focus on the future. And so now that we have this powerful social media, the law is so relevant today than even before. So if you share any information or a piece of write-up that is false and likely to cause public alarm, you are caught squarely by this. And the purpose of this law, in my view, is to ensure responsible use of these social media platforms and to ensure that we don't put information in the public that is likely to cause violence.
Daniel Enapanga, is it not too much work the law is giving me? If a friend of mine has shared something, put something on his wall, I have to take the pains to go and check to be sure that it is true or not before I also share it. Why? Isn't that too much work?
Well, but we all owe some obligation on our conduct that whatever you do, you are responsible for it. Samson, when we heard the news, the unfortunate news of the death of Daddy Lumba, I was at a meeting early morning when I heard the news. One of the persons I checked was A+. I checked A+ platform, I saw it. I was looking for 2 or 3 other people before I could say anything. Because you see, you need to take steps to verify. But just merely because a friend has posted something, the friend could be out on a mischief, or the friend intends to commit this particular offense, and you join him in committing the offense. Once you do that, you are spreading the falsehood. And the law says that if you spread the falsehood, unless you have taken steps to verify. If I take steps to verify, maybe I checked on Joy FM portal and it was so. Perhaps Joy FM 2 has been misled, or Joy FM is misleading the public, or has false information, and perhaps Joy FM also got their source wrongly. The law, that will be your defense that, oh yes, I took steps to check and I verified from these portals and it confirmed that the information was true. So I believed him to be true and I sent it out. But if it turned out that you did not do all that and you were too quick to spread information, you have committed an offense.
And Daniel, the law says it is not a defense that the person charged did not know or did not have reason to believe that the statement, rumor, or report was false.
Not end there. It provides a very important proviso which says that unless he proves that prior to the publication he took reasonable measures to verify the accuracy of the statement or the rumor or the report. What this subsection is seeking to do is to raise the bar so that nobody publishes an information and comes to tell us that I didn't know it was false, or I didn't have any reason to believe that it was false. The law is placing a heavy duty on citizens to ensure that before we publish anything in the public domain, we have to do or take steps to check the facts that we are putting up there, to verify, to ensure the authenticity of the news or the information that we are carrying to the public domain, and to ensure that it is accurate and is not intended to mislead and to incite unrest.
Okay.
So now, you can't just go to court and say that you didn't know.
Okay. Now, I'm going to get you guys, we have very limited time, I'm going to get you guys to tell everyone, anyone who is listening now and is on social media or gets into the public square, gets in the market and all of those places, what practical things they should do to avoid getting into problem with these laws. Remember, I told you earlier that some people have been jailed under these laws. I had mentioned earlier to you about Jeffrey Nyame, who got 30 days in jail. I mentioned also Muhammad Ibrahim, who got 4 years. He's actually still in jail over such commentary. And just 2 weeks ago or so, there was this other gentleman who also, a popular TikToker, who got about 17 months in jail for some of these kind of comments. So how should people avoid getting into trouble with the law? The two of you, I'll give you about 2 minutes each.
Very well.
And then I will end with Daniel, because Daniel is celebrating an anniversary that I want to be part of.
That's nice. So you even forgot, Shatawale himself is an ex-convict of this offense.
Oh, yes.
Spread news that he has been shot and turned out to be false.
That's right.
He was charged.
Yeah.
He pleaded guilty and he was sentenced to a fine. And so...
so that's part of his record.
Yeah, it's part of his record.
That's
so
very bad for him.
Can walk around, but he knows that this criminal record is hanging on his neck. That he has. But that aside,
well, he has his own business. He doesn't need anybody to give him a job. Nobody's going to ask him, "Have you been convicted before?" Yes,
a different world. So first thing is avoid the use of abusive words, threatening words, or behavior that could lead to the disturbance of the public peace. And if you ever even do that, be mindful of the space. You shouldn't be in the public space. If it's in your private conversation with a friend, but you see, the public space thing is also very fluid. If you are sitting at a beer bar having a conversation with a friend, you're at a public place. It's not a public meeting, but it's a public place. And so you must be mindful of the space. You can have private conversations in your home. You can have private conversation over the phone with a friend. You can have a private conversation on your phone with chats on WhatsApp or any other form of communication. But do not use the public space to issue out threats, abusive language, or insulting language.
Or even sharing.
Or on the other side of
such videos and things.
When you receive information, no matter the source, please verify. The first thing is verify. And mind you, don't just say that you verified. You may even need to have evidence of you verifying. If you can have a screenshot of you checking with some other media portal or some other source and it turned out to be true at the time you were sending it, that would be a good defense for you that at the time you took reasonable steps.
Right.
That would be a good step for you. But if you are so excited, perhaps you've been anticipating that, and it doesn't matter that the false news is either positive or negative. Once it is false, it is false. If it is likely to disturb the public peace, don't forget that it is the police that have the discretion to decide whether to prosecute you or not to prosecute you, to initiate processes against you.
Right.
And so once you are arrested, the police will continue, and then judiciary will now determine whether indeed the police have enough evidence or not. So avoid making such comments in public spaces and always verify the authenticity.
Thank you. Thank you very much. Yes, Daniel, what will be your advice? How practically can people, all of us on social media, avoid this? Do that in about a minute so that we can begin your anniversary celebration, 10 years, right here.
Thank you very much, Samson. Let me quickly mention that the number one thing that social media users can do is to do a fact check.
Okay.
Verify the authenticity of the information you're putting up there. That's number one. Number two, responsible exercise of the right to freedom of speech. You have to understand that the law gives you the right to freedom of speech, but with limitations. One of those limitations is that you have to respect the right of others. You don't exercise your right to freedom of speech to abuse others. Remember always that there is a law called defamation law. Somebody can take you up in a defamation suit, apart from the fact that you can also attract criminal sanctions and punishment. The third thing I will tell people is that think before you post anything on social media.
Think before you post.
Think before you post. Let this be our slogan. Think before you post. Question your own motives and intentions to see whether what you are posting is helpful, is beneficial, and good for public consumption.
Right.
And the last thing I will say is that ensure that you use social media properly. And to use it properly means to stick to these three things. Educate your audiences, entertain your audiences, and inform them positively. Avoid unnecessary information out there. Thank you very much, Samson.
Thank you very much, Daniel. And Daniel has always been with us and always available and accessible to help us give you some of this education. Daniel is going to be celebrating 10 years next month, 10 years of being at the bar. And he has written how many books so far?
Samson, I can boast of about 13, 14 books so far.
This is the latest.
And the latest.
The latest is How to Study?
No, the latest, I published 2 books last year, Sentencing and then Plea Bargaining.
Yes, Plea Bargaining, correct.
Year,
correct.
Yes. This year, I have written 3 books. One is a church material, and the law ones, the one we are going to launch now is The Spirit of the Ghanaian Constitution. Right. I'm going to launch that on my 10th anniversary, and then we are going to also launch another book winning celebrities for Christ. That one's a church material.
All right.
So the emphasis is on the spirit of the Ghanaian constitution, a very powerful material for constitutional law.
Congratulations, Daniel Krang.
Thank you very much.
10 years at the bar. Thank you very much. And you've done such a great job, such a prolific writer of legal texts. Daniel Krang is partner at Adom Legal Consult. He also teaches the law. He's based in Sunyani. And Apanga Lamteng is managing partner, Prestige Partners. I'm Samson, Lardy, Anyenini. I hope we have helped you, particularly in your engagements on social media, to avoid the Abronye 207 and 208 offensive conduct and false news laws, offenses. I'm Samson, Lardy, Anyenini. This has been The Law. It's your legal light. It is your help law.